In this week's 5-minute masterclass, I want to talk to you about Section 37 reports. Some of you may have come across these already if you've been involved in social services, you're a social worker or a health visitor. You may have already been asked to provide information to assist in the making and writing of a Section 37 report. So what is a Section 37 report? A Section 37 report is a report that is requested by the court when it is dealing with two parents or carers. There may or may not have already been a Section 7 report prepared by either CAFCAS or a local authority in those proceedings. And if a Section 37 report is requested by the court, what that tells us is that the court is really concerned about the welfare of the children and is asking the local authority whether or not, in making its assessment and coming to its conclusions, it feels it needs to take significant action to protect the welfare of the child. And that action includes applying to the court for either a care order, so that it would share parental responsibility with the carers and parents, or whether or not a supervision order is going to be necessary. So not sharing parental responsibility, but still having significant involvement in that family's lives. A Section 37 report isn't done lightly. It's a report often done when a judge is absolutely struggling with a case, where he or she feels that really some significant involvement is required in order to make sure that the child's welfare needs are being met. And it could be that a child, in the judge's view, may be suffering from emotional harm because of the level of animosity between parents. Maybe a child is at risk of psychological harm because of domestic abuse that's going on. Perhaps there's been a history of domestic abuse between the parents, and the child is now getting to an age where they may or may not become embroiled in that if there are altercations happening or there's difficulties at handovers with contact, things like that. It could simply be that the judge does not have a way forward. I've dealt with cases where parents simply have dug their heels in and have refused absolutely to do as the court has asked. And so the court then has to deal with that matter as seriously as it is, in the way that is most child appropriate to make sure that the child's welfare needs are being met. It's important to remember that when a judge makes a Section 37 direction, so he tells the local authority that there is going to be a Section 37 report and the local authority has to fulfil that, has to provide that report to the court within a set timescale, usually about 8 weeks. The court does have the power to make an interim order in favour of the local authority at that time. So if a judge is significantly worried about a child or children who are the subject of those proceedings, they can, when they make a direction for a Section 37 report, give the local authority parental responsibility for the duration of the report writing period. So the interim order will finish on the day the order was due to be filed, unless there's an extension given. But that means that the local authority will share parental responsibility if that order is made. So it isn't a simple order. It isn't an order that is made lightly by the courts. It's one that is very serious, and it's one that is has a lot of consequences to it. And parents are heavily advised to cooperate with those assessments, because the conclusions that are reached can have significant impacts upon the children in their care. And it's important to remember that the other agencies involved, so if you work for health, if you work for a school, you will all be asked for information to feed into that report, which will ultimately set out the local authority's recommendations for the children as to whether or not they need to share parental responsibility, and as to whether or not they need to take further action in terms of issuing care proceedings to make sure that the welfare of the children is being met.